What evidence is needed to show capacity? Have you ever wondered what it takes to prove that someone has the mental ability to make important decisions? This question is especially relevant in elder law, particularly when discussing guardianship and conservatorship. Understanding what evidence is needed to show capacity can help protect those who may be incapacitated. First, let's talk about the presumption of capacity. The law generally assumes that adults have the ability to make decisions and sign legal documents, including wills and trusts. This means that if someone challenges a person's capacity, they must provide proof that the individual lacked capacity at that specific time. Next, we need to consider what is known as testamentary capacity. This is the ability to create a valid will. To have testamentary capacity, a person must understand the nature of making a will and its effects. They should know what property they own and recognize who their family members are, as well as comprehend how they wish to distribute their assets. It is important to note that a person does not need to have perfect memory or top-notch decision-making skills. Even if someone is older or has some cognitive issues, they may still have the capacity to make a will during clear moments. Now, let's discuss the types of evidence that can demonstrate capacity. Medical evaluations and records are key. Assessments from doctors, psychiatrists, or psychologists who have treated or evaluated the individual can provide important insights. These professionals can testify about the person's cognitive abilities and any mental health conditions that may be present. Witness testimony is another important piece of evidence. People who were present when the individual signed documents can share their observations about the person's behavior and understanding. This can include attorneys, family members, or friends who can speak to the individual's mental state during that time. Documentary evidence is also useful. Written materials created by the person, such as letters or notes, can show their mental clarity. Videos or audio recordings of the individual signing documents or interacting can also be compelling evidence. In the context of guardianship or conservatorship, courts requiring formal proof of incapacity before appointing a guardian. This proof often includes affidavits or certifications from to medical professionals, such as physicians or psychologists, confirming that the person cannot manage their personal or financial affairs. If a person's condition improves, they can seek restoration of capacity. For attorneys working with elderly clients or those who may have cognitive issues, it is essential to conduct thorough interviews and document the client's responses. If there is any doubt about capacity, obtaining a medical evaluation is wise. Keeping detailed records of the client's mental state and decision-making process can help defend against any future challenges. In summary, showing capacity involves gathering a mix of medical evidence, eyewitness accounts, and documentation that demonstrates the individual's ability to understand and make decisions about their estate at the time of signing. This evidence is vital in elder law and estate planning to ensure that wills, trusts, and related documents are legally valid and reflected the true intent of the person.